Good afternoon, everyone. Before moving with the discussions, I would like to address a special thanks to Ana, to André, Felipe, and João, not only for the invite, but also for making this event possible. In the third panel, I will discuss arbitration in emerging markets. And when we say emerging markets, we refer to both emerging economies that need arbitration in order to provide a good legal framework that will allow business development. And we also refer to emerging arbitration markets, which means jurisdictions where arbitration became very popular, but still face some challenges, especially where the arbitration legal framework is not already well developed. And to discuss this topic today, I have with me three prominent experts in arbitration. Professor Fernando Dias Simões, who holds a PhD from University of Santiago de Compostela and is associate professor at the Faculty of Law of the Chinese University of Hong Kong. I have also Funke Adekoya, who holds an LLM of Harvard Law School and is founding partner and head of dispute resolution practice at ILEX. And third, we have also Adrián Magallanes, who holds an LLM from New York University and is co-head of the arbitration and litigation practice of Van Boeser and Sierra in Mexico. We'll have interventions of each one of the speakers, about 20 minutes each, and then we'll open the floor for discussions. We will start with Professor Fernando. Professor Fernando will discuss the battle of seats among emerging markets and the key ingredients for a country to become an arbitration hub. Professor Fernando, please, you have the floor.
Thank you so much, Bruno. Good night from Hong Kong. Good afternoon for those joining us from Europe and from Africa, and a very good morning to those joining us from the Americas. I would like to thank the organizers for the invitation to be here to talk about a topic that is very close to my heart and that I've been following for a few years, as Bruno mentioned, the so-called battle of the seats. We all know that international arbitration, at least its more contemporary shape, can be considered as an off-product of globalization, as over the last decades it has become, without any doubt, the foremost mechanism for the resolution of international commercial disputes. This globalization process, of course, raised the level of conflict, but also competition within this market for international commercial arbitration. And trying to address the needs of local and international business communities, both national and international legal systems around the world have taken a very firm pro-arbitration approach, not only enacting modern legal frameworks that we are all familiar with, but also trying to support arbitration proceedings in other ways. The amazing expansion of this market for international commercial arbitration can also be seen by the increased competition between different national legislatures and the multiplication of arbitral institutions all over the world and arbitral organizations. International arbitration has definitely become a market, and countries recognize a market opportunity in the expansion of international arbitration, and they aspire, a lot of them aspire to affirm themselves as focal points and receiving arbitral proceedings. This is what has been termed the battle of the seats. Unfortunately, I didn't really coin this expression. So different cities around the world, different jurisdictions strive to be considered as arbitration hubs. This basically means a place that is known for its reputation in hosting arbitration proceedings. Why? Because arbitration is very mobile, and by its own nature, it can take place anywhere. As we all know, living in the age of COVID, even online. So countries and cities all over the world compete to be chosen by the parties as suitable venues for international arbitration. And in doing so, they, of course, the different stakeholders in this market adopt a market-oriented perspective. Arbitration has clearly become a service industry. It is a very competitive market. It involves big business and mega lawyering. And in this legal industry, competition, of course, is ferocious. Competition between arbitral venues, also between arbitral institutions, between arbitrators themselves, of course, and even between arbitration conferences. And I am sure the Oxford Arbitration Day is a market leader, seeing from by the large number of people that are joining us from around the world. So arbitral institutions compete for a market share of the disputes. Legislatures enact friendly statutes to attract business, and we now have a class of full-time arbitrators traveling the world to hear these cases. As Bruno mentioned, I'm going to discuss briefly those that I think are the key ingredients for a jurisdiction to become an arbitration hub, or at least those jurisdictions that are not yet established as major arbitration hubs. Of course, as lawyers, we always start by improving the legal framework. We all know that arbitration depends on an effective and complex system of legal instruments that controls the status and the effectiveness in practice of arbitration and the resulting arbitral awards and their enforcement. So, of course, we always start by implementing measures to ensure the enforceability of awards, namely joining the New York Convention. We all know, last time I checked, 168 members, covers most jurisdictions in the world, establishes the golden standard for enforcement of foreign arbitral awards. So, of course, this is an easy measure. It's clearly one of the first measures that any country should adopt if they are interested in becoming full members of this international arbitration community. This goes along with the reform of domestic arbitration laws, of course, another typical measure adopted by jurisdictions who wish to make arbitration more a day-to-day routine part of the legal industry. In doing so, of course, they strive to adjust and improve existing legal frameworks, trying to achieve simplicity, flexibility, but also to be pragmatic. And the adoption of a new arbitration law, of course, also plays a role as a marketing strategy. It signals to the international community that this country is arbitration friendly and is part of this big community. In this regard, of course, we all know that the UNCITRAL Model Law from 1985, amended in 2006, is a very convenient template that allows countries to easily incorporate into their domestic legislation legal frameworks that have been tested all around the world. And a lot of countries have been doing this in the past, which results, of course, in to a high degree in the harmonization of international law and practice. Of course, this is not enough. An author has been termed this the flu of modernization of arbitration and harmonization of arbitration. But of course, this is not enough, and it is not sufficient. Harmonizing or bringing domestic statutes in line with the UNCITRAL standards should not become an obsession. And the model law is not a magic potion that instantaneously solves all the problems that these jurisdictions are facing. First of all, just because a lot of countries around the world, more than 60, follow this template, this doesn't mean that they have perfectly identical arbitration laws. in fact, model law jurisdictions adopt this template with different degrees of closeness. So harmonization doesn't mean uniformity. In addition to this, this is a legally recognized standard, recognized worldwide, but it is not the only standard that is available. In fact, around 2/3 of arbitration proceedings take place in jurisdictions that have not followed the model law. And interestingly, a lot of arbitration superpowers, in terms of number of cases, have designed their own laws, such as England, France, Switzerland, the US, and China. And so following model law allows countries to signal to the market that they have incorporated a legal framework that is recognized worldwide, but it is not enough to become magically a seat for international arbitration. Just look at the number of countries that have adopted the model law and are still not very popular arbitration venues. Finally, the arbitration law, at least in a lot of cases, is not necessarily decisive in a large number of cases, because frequently arbitral tribunals decide disputes with no more than a passing reference to the law of the place of arbitration. So it's not necessarily a decisive factor when it comes to the outcome of the case. In addition to legal reform, another important step is to create well-known and respected arbitral institutions. So legislation is not enough. We need manpower. We need people with know-how. And this, of course, depends to a large extent on the support of prestigious and efficient arbitral institutions. We have seen them mushroom all over the world. I used to keep track of every single time I would find some news about a new arbitral institution being established, from the Mauritius to the Bahamas and other very appealing places to hold arbitral proceedings, but at the Middle East, at some point I just stopped. It was like on a weekly basis. I believe that institutions, and this has been discussed by several authors, institutions should strive to achieve different specific goals, which may help to elevate their standing, starting, of course, with the neutrality of the center. Institutions should be designed as organizations that should try to be perceived as neutral and impartial. Of course, any institution is a bit of a result of a cultural background and has its own institutional culture, influenced by location, by the language that is more frequently spoken at that place. So it's only natural that Beijing is influenced by Chinese culture, just like Rio or São Paulo are influenced by Brazilian culture, but still they should try to be as neutral as possible. And this has, in terms of membership, in terms of leadership, administrative structure, and so on. Also, very important in my opinion, is to train qualified administrative staff. We all know that a good part of the success of an arbitration sometimes takes place behind the scenes, with all the administrative steps and all the administrative support provided by case managers, secretaries, registrars, which function is to ensure that the applicable rules are complied with. For instance, the Hong Kong International Arbitration Center has been promoting specific courses devoted to secretaries that more and more frequently assist tribunals in their work. And so, of course, these the training and development of skills of these actors that are frequently invisible is also important. Other steps which are traditional, normally performed by any institution, the creation of a list of qualified arbitrators, people with sufficient experience, especially in the first few years, where it is important to build a very nice website listing a lot of names coming from different jurisdictions, speaking different languages. It is, of course, in practice important that they are willing to actually create the necessary trust, especially in the first few years. It has been estimated, it has been said that arbitration is a credence product, in the sense that you cannot appreciate its quality immediately. It's not something that you buy, or you open the box and immediately you realize if it's good or defective. It may take between 5 and 10 years from the moment an arbitration agreement is signed until the final award and enforcement thereof, and you are happy with the decision that took 10 years ago to sign an arbitration agreement. So, of course, it is very important in the beginning to create this relationship of trust, because reputation brings more reputation. And even in the case of Hong Kong, in the 80s, when the HKIC was established, the caseload was perfectly negligible in the first few years. So, of course, it takes a lot of commitment. It takes cases to attract more cases and create a reputation for. So it's a vicious circle. It's the chicken and the egg. In the beginning, this can only be achieved not exclusively by arbitrators, but it is very important to bring in some heavyweights who can, not just with their reputation, but actually deciding cases in that jurisdiction, create this trust. And of course, then it will be easier to bring in new practitioners and train future generations. Technical qualifications, a diversity of national cultural backgrounds, a diversity of language skills, of course, is also important. I believe that in the future, it's already happening, but I believe that in the future, we will have 2 or 3 more world languages establishing themselves as clusters. And I'm happy to see that, thanks to the amazing work being done by our Brazilian colleagues, Portuguese is among those languages. So not just English and not just French, also Chinese, Spanish, other languages that parties are comfortable with. English is a lingua franca. We are using English so that we can all understand each other. But there's also, of course, a market, and there's room for diverse languages and different legal backgrounds. I believe that this is increasingly this can be increasingly a competitive advantage, to give the parties diversity, not just in the sense of legal backgrounds, common law versus civil law, but also cultural backgrounds and linguistic backgrounds. And of course, maybe even bring in more and more experts, not necessarily lawyers, but with hands-on experience in several specific areas and several different clusters or types of disputes. Of course, time and cost efficiency, we all know, is one of the main concerns of institutions and all practitioners involved. Arbitration is a business. Judges and courts don't really have to worry about attracting clients, but anyone making a living off arbitration, of course, need to consider that. Otherwise, clients will look elsewhere for dispute settlement services. In this regard, expedited arbitration, new methods of setting the fees, a competitive schedule fee, of course, can also be important. Also, very importantly, especially again living in the age of COVID and the travel restrictions, the use of technological tools. We are all aware that they also raise their own questions, namely potentially breaches of due process and the ability of the parties to fully present their case. We all know that not all law firms, not all parties are in the same conditions when it comes to access to technology. So some of them may be info excluded, may face particular difficulties, but there's also a world of opportunities brought about by the fact that most of us, I know that I was not very familiar with all of these real-time tools of communication, and we are now all, for better or worse, extremely technology savvy, and we are all experts on Zoom right now. And a lot of work has been done over the last 2 years. Not only cases decided, but also academia, for instance, has been following these developments and discussing potential how to take out of this health crisis, turn it into an opportunity to learn, and eventually how many flights will be avoided, and how much carbon print will be reduced, and how much time and money it will save to the parties if everyone is actually comfortable with the use of new technologies and they become the new normal. That would be a very nice silver lining for the terrible period that we are going through. There are, of course, other minor marketing strategies that can be used. For instance, the creation of purpose-built facilities. An example of this, the town hall in Korea, in Seoul, financed a few years ago some specific facilities designed exclusively receive arbitral proceedings. This is another creative way of signaling the commitment of a city and the whole country to become an arbitration hub. My last suggestion, of course, is always the training of skilled professionals, especially judges, who frequently have some sort of rivalry and resistance in playing their role in arbitration, in the support of arbitration culture, and also practicing the training of lawyers who frequently approach arbitration proceedings with the same mindset as if they were in court, and that is a disservice that they are doing to the arbitration culture and to the arbitration industry. I ran out of time. Thank you so much for your attention, and I will be happy to answer any questions afterwards. Thank you.
Thank you so much, Professor. It was a very interesting presentation. Also, if you want to make questions to Professor and to other speakers, you may just make some comments on YouTube and we'll have access to those questions. I'll now turn to Funke. Funke will share with us some thoughts on trends and challenges of arbitration in developing countries, especially in the Caribbean, and especially also in the conflicts arising out of state company privatization. Funke, please, the floor is yours. You have to turn on your mic.
Thank you. I will look at the topic from the perspective of challenges in Africa regarding arbitrations that have come out of privatization. And why do I take this perspective? Perhaps because of the history of African countries as having been colonized, and against that background of colonization, many African states had owned and controlled virtually all aspects of their economy, especially the extractive industries, but in addition to which, a large proportion of their industrial, their manufacturing sectors, even commercial aspects of the economy used to be in state hands. Plus, of course, infrastructure, which is generally one of the things that government is supposed to provide for its people: roads, bridges, dams, airports, and things like that. And African states have generally been slow and reluctant to let go of these assets, to privatize. They've been pressured into it either because they have sought World Bank financing or they have sought IMF support for their economies. And these have been part of the conditions that have been laid down as a means of access to financial bailouts. So what we're seeing now is a change in the structure of many African emerging markets, moving away from an economy which is government owned and government controlled, and moving toward what the Western world says is the laissez-faire market economy, where the economy is controlled by the private sector, owning the assets and the tools of business, and depending on the areas in which they operate, subject to minimal or sometimes maximum regulatory control. So that's where we are in Africa. Then for African countries that have privatized, some privatizations have been total and some have been partial. Total privatizations have tended to be in areas where, for instance, government-owned hotels, newspapers, trading arms, and government just got out of that entirely. So that was a total privatization. Partial privatization has been where the government have sold equity in government assets or in government-controlled businesses to the private sector, but have retained an investment and a stake in those businesses. And in addition, have then, as a recourse to giving up ownership, have then tended to regulate that aspect of the market. So you find out that where privatization has taken place, the transaction documents will tend to have an arbitration clause, either in the share sale and share subscription agreement, or in the shareholders agreement, or in the technical management services agreement between the government entity being privatized and the investors. Now, where those investors are foreign investors, they then have two bites of the cherry, or two options. In addition to the commercial arbitration provisions that are available in the transaction documents, if there is a bilateral investment treaty between the country of the foreign investor and the host state, there may be an option to recourse as well to investment treaty arbitration, depending on the transaction in each case. So when emerging African economies are privatizing, these are one of the things that they need to look at. They're laying themselves open to both commercial arbitration and possibly to investor-state arbitration. And African countries as a whole have signed over 600 bilateral investment treaties. Not all of them are in force, but it shows the enthusiasm to attract foreign investment. And they see the signing of bilateral investment treaties as one means of achieving this objective. So against this backdrop of privatization, where does arbitration and dispute resolution come in? Africa's first collision between privatization and arbitration was the result of the Arab Spring. When the Mubarak government in Egypt was toppled in 2011, the result of that change of government was an outpouring of agitation, urging the new government to investigate the circumstances in which certain state assets or state entities have been privatized. Allegations of cronyism, corruption, undue influence were being leveled at the Mubarak government, and the new government was asked to look at this. And the result of that was that third parties, and I'll come to that at a later point, third parties who are not government entities and were not investors in the privatized entities, actually then commenced domestic proceedings before Egyptian courts asking the courts to re-privatize or renationalize those privatized entities. And they were pretty successful. I think the most famous case would be the Indorama case, where as a result of the successful decisions coming out of the Egyptian tribunals, nullifying the privatization agreements that the Mubarak government had entered into, Indorama actually brought investment treaty arbitration against Egypt because its investment in a textile factory had been renationalized. Egypt eventually settled that case. The claim was for 156 million United States dollars and was eventually settled for about between 50 and 53 million or thereabouts United States dollars. So that was a fair amount of money. That settlement came in 2015. There are other claims that have been made by investors as a result of those decisions, renationalizing previously privatized entities. And the government of Egypt is in the state of settling those claims. So let's keep that. That's Egypt. Let's now move to Nigeria, my home country, where privatization has been in force since around the 1980s. And most recently, 10, 15 years ago, what has happened has been the privatization of the electricity sector. Now, the electricity sector was initially totally owned in every aspect by the government: the generation, the transmission, and the distribution side of it. When the government then decided to privatize some aspects of the electricity sector, it restructured the electricity industry into various companies, distribution companies and generating companies, and sold off the distribution companies. They were sold to Nigerian incorporated entities, some of which have substantial foreign investment. The result of that exercise was that 11 distribution companies were created and sold, and 7 generating companies. The transition arm of the electricity sector remained with government, but it was concessioned. The concession expired and was not renewed, and the transmission arm is still in the arms of government. The government then set up a regulator to regulate the activities of those private sector investors in the electricity sector. The result of that regulation has been an increase in tension between the distribution companies, the DISCOs, and the government regulator. Arbitration has been threatened, but to the best of my knowledge, arbitration has not yet been instituted. Many Nigerians believe that the privatization exercise has failed and have been pushing for the federal government to take back those power firms, renationalize them, or re-privatize them. And that would then involve either canceling or not renewing electricity licenses of the current operators, which, if I'm correct, are due to be up for renewal in the next 24 months. As recently as January 2020, the head of Nigeria's upper chamber, its Senate, in the legislative arm of government, during a discussion on power sector reform, actually stated, and was quoted in all the newspapers, that the power sector privatization program had failed and called for a total review. So we're all watching and waiting to see what is going to happen in that sector. Let's then move to South Africa. A couple of years ago, there was a lot of discussion in the South African newspapers as to whether Eskom, which is the South African equivalent of Nigeria's structure pre-privatization. Eskom controlled transmission, generation, and distribution, and still does. And there was a lot of talk as to whether Eskom should itself be restructured into a generating arm, a distinct transmission arm, and a distinct distribution arm. And perhaps one or other of these arms should be privatized. This discussion seems to have been put on hold because as a result of a commission of inquiry into what has been termed state capture, where private individuals were found to be unduly in control of government assets and the ability to influence what was going on in government organizations, including Eskom. It seems as if the discussion as to whether or not Eskom should be privatized has come to a stop at this point of time. Now, the reason why I'm discussing this is because, as I said, emerging economies need money, need funding. The World Bank or the IMF says, well, you need to restructure your market. This happened in the Caribbean. And as recently as 2019, there was a case that went to ICSID, a Caribbean country, Grenada, had the same system that Nigeria has, an electricity sector that was a government monopoly. And when Grenada decided to privatize its electricity sector, it sold the sector to a foreign investor, still as a monopoly. As a result of pressure, perhaps from external sources, when Grenada then decided that it was actually going to deregulate or restructure its electricity sector and break it into a generating arm, a distribution arm, and a transmission arm, the foreign investor then challenged that government legislation as expropriation of its investment and a breach of its privatization agreement, and did so successfully. And so it becomes important for all parties looking at changing their legislation after they have entered into a privatization arrangement in any sector to be aware of the potentials of arbitration resulting from changes in legislation. Now, I'd then like us to have a quick look at the legal framework in these circumstances as a result of the facts that I have stated. So in Egypt, as I said earlier, the cases that resulted in privatization claims were brought by third parties. And that is because third parties under Egypt's constitution, under Mubarak, had constitutional rights in the constitution to protect public money. And this enabled third parties to bring these cases to court. And after the Arab Spring and the revolution in Egypt, over 7 of these privatization cases were brought to court and were actually nullified. So what then happened? Firstly, when Egypt reviewed its constitution, it took out those third-party rights. In an effort to further protect investors, it established a law in 2015, and that law restricted the rights of third parties to challenge commercial contracts awarded by the government. And this was in direct response to the ability of third parties to challenge privatization and the issues that had come out of it. In addition, Egypt enacted an investment law which sought to create out-of-court forums that would lead to a settlement or a mediation or encourage a discussion as to how to settle any issues that have arisen as a result of investment in government entities or purchase of government assets. Now, looking at the rest of Africa, there are areas in which governments and emerging economies on the continent have taken steps that are not directly privatization, but have also have affected investor rights. South Africa and Zimbabwe are prime examples. The Black Empowerment Act in South Africa enacted post-apartheid was meant to ensure that Black South Africans had equal access to the South African economy by regulating percentage shareholdings in entities and preserving percentages for job creation. In Zimbabwe, the Land Transfer Act was meant to equalize the opportunity of Black Zimbabweans to have access to land owned.
I think Funke got a connection problem. I'm not sure whether Funke is returning. Whenever she returns, and afterwards we'll give her the floor again to finish her thoughts. I'll now turn to Adrian. Adrian will share now. Actually, now we'll turn to Mexico. Adrian is Mexican, and she will share his experience and discuss challenges, especially on infrastructure and investment matters in Mexico. Adrian, please, you have the floor.
Thank you very much, Bruno, and thank you very much to the organizers of the Oxford Arbitration Day. It's a privilege for me to be here. I have a PowerPoint presentation. I don't know if that could be shown. If not, that's okay. I can follow on simply giving a conversation. I would like to discuss two topics. The first topic involves arbitration trends in Latin America. What's the status of arbitration in Latin America? And the second part is following up on what Funke was mentioning, the changes in the Mexican power sector. Now there are discussions of achieving a reform by which the privatization reform that was enacted in 2013 is no longer in force. I noticed that Funke just got her connection back. I don't know if we want to switch.
Actually, Funke, you are now back. Do you want to finish your thoughts? Close your arguments?
Yes, I had nearly.
Thank you, Adrian.
So let me just round up and speak from having laid these issues down. What are the challenges that I see of arbitration in developing countries? The first thing is that where states manage their foreign investments through state entities or state-controlled companies, they lay themselves open to both commercial arbitration and investment treaty arbitration. I'll leave that as that. And then what are the challenges that I see? From my perspective, sitting as an arbitrator, I think there is still an inequality of arms with respect to legal representation before arbitration tribunals in investor-state disputes, especially. Investor-state disputes invariably cost a lot because there is a lot at stake. And therefore, it doesn't make sense for African countries to cut costs by not going for the best. In which case, how then do they train up their own nationals to be able to properly represent them? And I would suggest that even if an African country is hiring a specialist investor-state law firm to represent it before a tribunal, you could then ask that this government state council or lawyers in the domestic law firm assisting should sit in the offices of the specialist law firm to see how things go from the back and thereby gain the requisite experience over the years. Having said this, there are African firms and there are African state council that are competent and knowledgeable in terms of both international commercial arbitration and investor-state arbitration. Then from my perspective as counsel, what do I see? As my perspective as counsel, I'd like to go back to Fernando's discussion about the state versus the seat debate. African emerging economies always want African seats. The truth of the matter is, are we ripe to have African seats? Maybe what we should be pushing for is to have African venues. And therefore, if African states can ensure that they have good transport links, good hotels, secretarial support, transcription services, hotels, all the things that will enable arbitration proceedings take place in country, then they can push for arbitration venues. Once that is done, then African countries can push to ensure that their court systems are awake and alive to the nuances between arbitration and litigation and can properly support arbitration. And that is what will ensure that African seats will become a venue, a location for arbitration, in addition to just being a venue. So I'll stop at that point. I'm sure I've gone over my 20 minutes. Thank you.
Thank you so much, Fat. I'll now turn again to Adrián. Adrián, please, you have the floor.
Thank you, Bruno. Thank you, Funke. As I was saying, I would like to then begin this conversation or divide this conversation in two sections. These sections are unrelated, but nonetheless, I think they're interesting. The first one is the status of arbitration in Latin America, the experience, the trends, and the challenges. And the second section is the energy reform being discussed in Mexico and the implications this possible reform may have to arbitration. Regarding the status of arbitration in Latin America, and here I'm referring by the numbers. If we compare what the situation was 15 years ago, we would see that in 2005, the number of arbitration parties or the number of cases involving Latin American and Caribbean parties was 170. 15 years later, 2020, the number of parties in ICC cases, and I'm sorry if I didn't clarify this, these are ICC statistics, it's 386. So there's a very substantial growth in the number of parties being involved in ICC proceedings. Now, if we see the number of ICC arbitrations that are seated in Latin America, and I come back to Fernando's discussion on the battle of the seats, if we go to 2005, we would see that we have 20 arbitrations that were seated in Latin America and the Caribbean. Now, 15 years later, 2020, there are 69 arbitrations seated in Latin America. So there's an increase of over or very close to 250%. Now, if we see the number of arbitrators being appointed, the number of ICC arbitrators from Latin America and the Caribbean back in 2005 was 70. Now in 2020, it's 236. Again, an increase of 200 or more than 200%. As developing economies, there are many ongoing projects, and many of the construction disputes in the world are being held in Latin America. Around 23% of international construction disputes relate to projects in Latin America. This was a very interesting percentage or statistic. I reviewed an analysis, a survey on international arbitration published by Queen Mary and Pinsett Masons. It's driving efficiency in international construction projects. If you see those statistics, you would see that the number of cases involving projects in the world was divided as follows. Middle East and North Africa, 55%, Europe, 31%, Asia Pacific, 29%, Latin America, 23%, as I was mentioning, Sub-Sahara Africa, 14%, North America, 13%, and Oceania, 7%. These are, I believe, interesting statistics because, as you know, many of the very large disputes in the world are related to infrastructure, to projects. Now, what's the status on the regulation of arbitration in Latin America? Firstly, the immense majority of Latin American states are signatories to the New York Convention. So this is very important. However, most of the world is a signatory to the New York Convention. Now, there are 11 Latin American states that are recognized as having implemented the UNCITRAL Model Law. And coming back to what Fernando was saying, this sends a signal of how Latin American seats want to demonstrate that they are equipped to be seats of arbitration. Now, regarding investor-state disputes, the ICSID Convention is a little bit more mixed. As of today, 13 Latin American states have ratified the convention. Bolivia and Venezuela denounced the ICSID Convention back in 2005 and 2012, respectively. And Brazil never has joined. In 2009, Ecuador denounced the ICSID Convention, but just this past summer of 2021, signed and ratified it once again. Conversely, Argentina, as well as Mexico and Costa Rica, among others jurisdictions here in Latin America, have participated actively in the ICSID rules amendment project. And Mexico ratified the ICSID Convention back in 2018 by the past administration, federal administration. Now, what is the status of the compliance with investor-state awards? Have Latin American countries complied with these decisions? Now, Latin American states also have a mixed record on the compliance with investment awards rendered against it. As of the end of 2019, and this is information that I found only up until 2019, 63 investment arbitrations had been filed against Argentina. 22 were settled before the issuance of an award in damages. 14 of the 19 damages awards to have been rendered against it are known to have been satisfied. And I did not find details on the other cases. Now, but that same point, 58 investment arbitrations have been filed against Venezuela, who had denounced the ICSID Convention in 2012. 6 were settled, although proceedings have been reopened in one. 20 damages awards have been issued, and 2 are known to have been paid in full. And since 2013, there's evidence of only 1 award having been complied with. And foreign actions were ongoing with respect to 10 of the awards. Now, regarding Mexico specifically, Mexico has a very good track record in award compliance. All of the 9 damages awards that have been rendered against Mexico, the government has complied with all of them, except for the very recent award of Lion versus Mexico, which is a $47 million award. This is the first award that was issued in the present federal administration, and it is yet to be seen how the government will react with respect to this award, whether they will try to annul it or whether they will pay it, or it remains to be seen. And this is, again, the first award that has been issued under this new administration that changed in federal administration that changed very recently, or around 3 years ago. What are the specific challenges I see? Well, firstly, if we talk about investor-state arbitration, I believe these challenges are not very different from the other challenges the world is facing. All these discussions on legitimacy, transparency, and I believe also apply here. Now, regarding commercial arbitration, I think here the challenges are far more visible. And I think there's one particular discussion that is, I wouldn't say common in Latin America, but that many countries are facing, which is the constitutional control of arbitral awards by judicial courts. As you know, constitutional remedies in many Latin American countries are available against judicial judgments, but not against arbitral awards. And there have been discussions on whether these arbitral awards could be challenged on a constitutional level. Regarding Mexico, this discussion was resolved through case law around 5 years ago, holding that awards are the products of a consensus between private individuals and therefore are not a government state-regulated activity. In Mexico, only state-regulated activity can be subject to constitutional control, except under many limited circumstances, private individuals cannot be held to constitutional control, and arbitration was deemed not to be one of these exceptions. So awards cannot be challenged through that. The other challenge is public policy and the manner in which public policy is interpreted. The way in which Latin America have read public policy varies depending on the country. Regarding Mexico, we have a very relevant case that was an annulment case that was initiated by the Federal Electricity Commission. And in that case, the Federal Electricity Commission argued that the award breached the policy behind the government-owned company regarding the energy infrastructure in the country. So they advanced an argument saying that this policy regarding how the energy should be distributed and how this infrastructure should be run was a matter of public policy for purposes of annulment of the award. And the Supreme Court said, no, this is not a matter of public policy. This is the political considerations or the political vision that a government may have may not necessarily be a public policy. And they came on to give a general explanation of what public policy was, saying it constituted an identification with these major institutional and fundamental principles of the system. And this was not one of them. And that case became highly relevant and has set the tone for other decisions of lower courts. However, I do know this is being also discussed in other jurisdictions. And another challenge that I see, and this might be relevant perhaps not only to Mexico, but is certainly very important in Mexico, which is the legal impossibility to attach assets against the state. There's no this distinction that is internationally recognized of having assets that are for commercial use and assets that are used for a public function is not recognized here in Mexico. So any award that wants to be enforced against the federal government or its institutions or agencies cannot end up in an attachment. There have been discussions on whether this is constitutional, but so far there has not been a single case by which the Supreme Court has ruled that this prohibition is or not constitutional. There was one that the Supreme Court was going to resolve. However, this was a case involving the Federal Electricity Commission, and they decided to settle the case before the judgment was issued. So this is the general scenario in Latin America. And I would now like to discuss the energy reform that we are facing here in Mexico. And this relates to what Funke was mentioning of how states need to be very careful when they want to change the regulatory regime from the private sector to the government again. And this is exactly the case here in Mexico. Historically speaking, the government has controlled the generation, transmission, and distribution of energy. And these go back several decades ago. However, back in 1992, under the administration of the PRI, political party then in the regime, private investment was allowed to generate power, but to the purpose of selling it to CFE. CFE, the Federal Electricity Commission, a government-owned company. So the private investors would generate electricity and then sell it to CFE. Now, this worked for many years, but again, CFE had the monopoly. In 2013, in December, there was a constitutional reform that converted CFE from a decentralized organ of the state to a state-owned enterprise and a participant of the market. The National Center for Energy Control was separated from the Federal Electricity Commission and restructured, and this National Center for Energy Control was in charge of operating the national grid, but having in mind that there was a new market. And private parties were allowed to carry out power generation and supply activities. This reform had a very deep impact. A new agency was created in charge of granting generation permits and determining transmission and distribution tariffs. Private parties on behalf of the state, very similar, I believe, to what Funke was saying, were allowed to finance and maintain infrastructure required for transmission. The legislator was instructed also in this constitutional reform to enact regulations aimed to achieving energy efficiency, emissions, and waste reduction. Now, out of this 2013 reform, now we had free competition in Mexico. We had clean energy certificates, which is a financial instrument that allows non-clean companies to achieve their energy, clean energy targets. And the market was functioning. A lot of investment came through during this period. And however, in 2018, a new federal regime entered in place here in Mexico. Mr. Andrés Manuel López Obrador took office as president, and he has a very different view. His administration has a very different view of what the Mexican electricity sector should look like. And for the past 2 years, several different regulatory changes have been implemented. However, most of the energy participants in the market have filed for amparos. Amparos are constitutional challenges in Mexico, and they have prevailed. They obtained injunctions against many of these changes, and they have obtained favorable judgments. After these regulatory changes took place, the government decided to enact a new Energy Act. This Energy Act was adopted by Congress, and it was, I wouldn't say a synthesis, but it comprehended many of the changes that did not pass through the regulations. However, again, the participants in the market filed hundreds of amparos, and injunctions were granted. And now the situation is that this new Energy Act is not producing legal effects because of these injunctions. Since that is the situation, the federal administration decided to reform the Constitution. And very recently, they have submitted an amendment proposal that is now being discussed in Congress. If one reviews this constitutional amendment proposal, well, the changes are quite drastic. Firstly, all the permits and all the contracts that are now in place will be cancelled as a consequence of this constitutional reform. Secondly, there's a distribution of the market. The government will generate and supply all the energy for 54% of the market, and private generation will be and distribution will be allowed in 46% of the market. I do not know what is the reasoning behind these percentages, but this is what the constitutional reform mentions. It is unclear how this 46% will be allocated within the private sector, and this has generated a lot of uncertainties, particularly because of this provision in the amendment proposal holding that all permits and all contracts will be cancelled. So out of the discussions that there have been in the country, this amendment was supposed to be discussed in this legislative period, which ends before the end of the year. However, one of the political parties just informed the public that the discussions were going to be prolonged to April of next year, and another political party that just announced that they want the discussions to be prolonged even further. So the status right now is of uncertainty. If this constitutional amendment goes forward and the 46% allocation of the market causes damages to foreign investors, it is very likely that several investor-state arbitration claims will be filed against Mexico. Among the provisions that will likely be invoked is fair and equitable treatment, indirect expropriation, and possibly national treatment. Now, of course, all of this is all speculation. One needs to see what happens. But the truth is that Mexico has a very wide network of treaties involving the protection of foreign investment. We have over 30 treaties, and most of the countries that have invested in Mexico, or most of the investors in Mexico in this sector, come from countries that have these treaties. So it's going to be very interesting to see how things develop. And of course, this may impact investor-state cases in a very important manner. Many of the investment comes from Japan, from the US, and from Spain. And we are all familiar with all the Spain cases. So during the several months, we will see how things develop. But that's the state of Mexico right now.
Okay, thank you very much, Adrián. Amazing presentation. Before I have some comments and some questions before asking them, or I would like to inquire if the participants and panelists, if you have any comments or questions to the other panelists. Funke, any comments or any questions? Your mic.
Sorry, no questions from me, other than I will definitely be following what's happening in Mexico. We're probably a little bit behind, but we might be on that track.
Okay, thanks. I'd like to, actually, I heard all of you discussing relationship with state courts, and Adrián stresses discusses the compliance with investment awards, arbitration awards, and also enforcement of awards. I'd like to hear and actually to ask and to hear from you, what are your thoughts regarding your experience, your jurisdiction, if you want to share with us, or the status of challenge of awards and status of enforcement of awards in your jurisdictions, and how that impacts your jurisdiction as an arbitration hub, perhaps touching on the topic discussed by Fernando. Who would like to start? Please, Funke.
Yes. Nigeria is a signatory to the ICSID Convention and also has a UNCITRAL Model Law based legislation, although we have not updated it from the initial version that came out. We also have an Investment Promotion Act. And under the terms of the Investment Promotion Act, ICSID awards will be enforced as if they are judgments of our Supreme Court, which means they are not appealable. If there are any ICSID awards, they just come to Nigeria, they're registered, and they are enforced. Having said that, I think Nigeria has had 3 cases at ICSID so far. I believe 2 have been settled, and 1 was unsuccessful against Nigeria. So we have not had any experience of having investment awards or ICSID awards. In respect of foreign commercial arbitration awards, recently a study was conducted in country in respect of how the Nigerian courts respond to arbitration awards. And the results of that study showed that in more than 80% of cases, arbitration awards, whether domestic or international, were enforced. Where the problem was seen was the period it took to get those awards enforced. So you could register your award in Nigeria, and it could take 18 months to have your enforced. And then there's a possibility of a further appeal against the decision to register and enforce, and that could take a further 2 years. At the end of the day, however, the study showed that by a wide majority, arbitration awards are enforceable. The problem is the time it takes for the courts to hear the proceedings and give decisions. That's my contribution.
Okay, thank you so much. Who's next? Perhaps Fernando?
Yes, I would like to pick up, since we are talking about investor-state arbitration, which is my favorite field of research, actually. I've kind of migrated from commercial arbitration to investor-state arbitration. Something that Adrian mentioned, the cases against Spain, and I have a particular interest in those cases, and I've been writing about them. It is interesting to note, I don't know if you are aware of this. A few months ago, Spain enacted a law basically promising the previous regime to those investors who dropped their claims. Are you aware of this? You can imagine the effect that this type of new legislation can have, not only for claimants who did not succeed against Spain, because Spain didn't actually lose all the renewable disputes, even though things are not looking very good for Spain, but in particular for ongoing cases, because this seems like an acknowledgement that in some cases Spain went beyond what the fair and equitable treatment standard, or breached the fair and equitable standard, and went beyond their sovereign discretion and their policy making space. I don't know if you are aware of this development. I confess that I have not been following that issue since January. No. Okay, so
I'm sorry, Fernando, could I just drop in? Could you repeat what was it that Spain promised? It promised.
I'm referring to the cases of the renewable energy solar panels against Spain. Around 50. Yes. So
I'm aware of
this. Yeah. Last time I checked, last time I checked, Spain lost like 2/3 of the cases.
Mm-hmm.
Italy had a good track record, I remember that, but Spain was losing heavily. And somewhere like in January, I remember this because I was finishing updating my records because I was concluding an article on this, so I have to check the last information available. In November last year, Spain enacted a law promising basically to go back to the original regime, but only for those companies that dropped their lawsuit. And some of them had already won the case, so they were about to enforce the award. And this is I think this is a groundbreaking development, because in terms of strategy, I wonder what some of those counsel will recommend their clients. Do you want to keep in good terms with the host state and benefit from this regime? So now apparently Spain believes that the promise is quite stable, when previously claiming we never promised anything would be forever. So I did, but to be honest, I didn't follow the most recent development. So I have not been following that. But I will happy to share with you the articles that I wrote about this. And there's one forthcoming where where I basically describe the difference between the cases and the different outcomes. If you find that relevant.
Thank you. I would look forward to seeing it, the article.
Thank you, Fernando. Adrián, like to share some thoughts? Your mic, Adrián.
Sorry for that. I also look forward to reading those articles, Fernando. And regarding Mexico as a jurisdiction, the percentage of awards being annulled is extremely small. Mexican arbitration practitioners, we are very proud of that. There was some domestic institution, or there is a domestic arbitration institution in Mexico that advertised itself that no award has been annulled issued under these rules. No award has been annulled. They are no longer advertising that. This advertising was a few years ago, so I'm assuming this changed. But the percentage is very small. No one, to my knowledge, has made an analysis of how many cases, what's the percentage. But I am aware of only 3 instances in which awards were annulled. And I have asked colleagues, and we all identify the same 3 cases. Of course, it is likely there's more, particularly more that are not cases that are very obvious or notorious. But the statistics are quite impressive. However, the same situation that Funke describes, of course, in Mexico. If you want to enforce an arbitral award, it'll probably take around 2 to 3 years to actually get to attach assets. So this is discouraging to some. However, I do not know what the average worldwide is to enforce an award. 2 years or 2 or 3 years, of course, sounds disappointing, but I'm not sure what's the average worldwide. In any event, that would be, even though there is a very, very small statistics of awards being annulled, this, of course, signifies expenses and legal fees that are coming back to the battle of the seats, that this is an issue that Mexico needs to work on. I'm not sure how easy this problem can be solved, to be quite frank.
Okay, thank you, Adrián. Actually, we have a question from João Moreira, our friend João Moreira. He asks, in our view, what can the arbitral community and arbitral institutions do, if anything, to guarantee that arbitral proceedings are not abused in the context of transnational corruption. This is an important issue to emerging, an important topic to emerging markets. I know it's a very complicated question. I'm not sure if João is actually our friend, but this is the question he made, and I'd like to hear your thoughts on that. Would like to comment?
I can kick off the discussion. Actually, drawing a parallel between commercial arbitration and investment arbitration, and back to commercial arbitration. Of course, ethical standards have also always been a concern of the community, at least since the 80s, when the IBA enacted the first ethical rules on international arbitration, and later the IBA rule of interests. And we all know how later they were also applied increasingly by investment tribunals. To address, of course, corruption is not a common problem, but to address other serious concerns, namely impartiality and independence, and so on. My perception is that they have been working well in commercial arbitration. Clearly, there is now a consensus that they don't seem to be enough in investor-state arbitration. And that's why Working Group 3 of the UNCITRAL is drafting, as we speak, discussing the third draft of the Code of Conduct for investor-state arbitrators, which I have been following closely because this is really my ongoing topic of research. To answer João's question, who should do something about this? Legislators at the international level. So I believe UNCITRAL, for instance, namely Working Group 2, that normally deals with arbitration, is the right forum to discuss these questions, because they have an international dimension, and they are particularly important in jurisdictions where the arbitration culture is not yet well established, or the rule of law is not enforced so thoroughly, and so they may be prone to manipulations, and arbitration may be seen as the Wild West. And of course, there are temptations that we are all aware of. Just like in courts, many countries have problems with judicial independence. My hint, my guess, not supported by any evidence, of course, because I cannot read into the future, is that if in the future we have a code of conduct applying to investor-state arbitrators, there will be some spillover effects into commercial arbitration. Commercial arbitration, as you know, is not as polemic as investor-state arbitration, fortunately. But I wonder if in the future there will be more and more people raising the same issues. There are no public interests involved normally in commercial disputes, but still there may be some spillover effects, especially taking into account that the two communities are not completely separated. Some individuals may switch between the two communities, and that may create some concerns. But that's just my take on that issue.
Thank you, Fernando. Anyone else? Funke, please.
I'd like to look at it from the perspective of where allegations of corruption are raised in the context of the award of the investor contract or transaction. Obviously, Nigeria is in the news at the moment because after a tribunal had concluded and granted an award against Nigeria in probably what has been the largest commercial award of damages yet, well, other than UCOS. The government was then allowed at a very at the enforcement stage to raise the issue of corruption having been a factor in the contract which was breached having been procured. I take this as a signal that courts will if the issue of corruption is raised and can be substantiated, no matter how late in the stage of the game, then the courts would look at it and would not enforce awards arising out of corruption or corrupt elements. And I think this would open a new vista going forward. My fear is that parties may go through an arbitration process from beginning to end and not raise a defense of corruption during the process. And after the award has been given and there's an attempt to enforce, will then raise it at the point of enforcement and say, do not enforce the award. It would be contrary to public policy because the contract out of which this dispute arose was induced by corruption. So we're watching and waiting.
Great.
Maybe
Adrian, some thoughts on that?
may I just add?
Sure.
I was referring corruption by members of the tribunal. I was not referring a contract procured by, because I remember my impression is that that's what happened with the other person, right?
Yes, I'm aware of the aspect you answered, and I looked at it from another aspect.
You looked into the contract, or normally the contract, for instance, a concession contract was procured through corruption of government officials, right?
Exactly. Yeah.
Okay.
But that aspect was not raised during the proceedings.
Adrian, any thoughts?
No, I agree. If a contract is procured through fraud or corruption, there should be no remedy for that, and the claiming party should have no standing. There's discussions on whether this is an issue of the merits or an issue of jurisdiction. They should, and the discussion has been held in the investor state level. I can remember the Inceiza Vallisoletana case versus El Salvador, where not necessarily corruption, but a fraud or accusations of wrongdoing. And there the tribunal ruled that there was no jurisdiction. But then subsequent cases ruled that there was no, that the claim could not be held, or even though there was jurisdiction. In the commercial arena, since the arbitration clause is independent from the contract, from my perspective, the tribunal would have jurisdiction, but the claim would be would not be favorably ruled upon. It would be rejected. Nonetheless, the arbitral tribunal would have jurisdiction. So technically, in these cases, the issues of jurisdiction and merits should be carefully analyzed. But corruption undoubtedly is an important defense, and one that needs to be raised and not to be used strategically, which should be immediately raised when known upon, and not to be used strategically, as Funke was mentioning.
Okay. Thank you all for the comments. I think it was very interesting discussion. Unfortunately, we ran out of time. We don't have any. I shall close this panel. I just inquire if any of you have any final comments, something you wanna say before we're closing. That's all good. I want to thank you all for all the audience for your attention. Thank you all the panelists for the very interesting comments and thoughts you brought this afternoon. And finally, thanks once again the organizers of this event for this putting together amazing people and great discussion on this forum. Thank you all. Bye-bye.
Thank